Hey, this is Casey Ashmore coming to you from the studio. Just doing a quick wake up your business pro tips, some ideas about how to protect yourself, how to protect your business. We've been talking a lot of things have been covered. One of the things that I want to talk about with is communications once the case is started. One of the best things that a client can do when a case has started is silence, right? Or limiting communications to something old school, a telephone, a rotary phone, I don't care what it is, a smoke signal, something that does not have to be produced in a discovery request, right? So a text message, an email, some phone systems, VoIP, voice over internet protocol, can be requested and transcribed, especially if they're, through certain vendors like the U.S. Marshal's Office, the jails, the prison systems. Those calls are all recorded. They're not transcribed immediately, but they can be requested, obtained, given to a court reporter, and transcribed. Being cautious about what you're putting into the ether. The communications between the business owners, once a dispute has started, are generally not protected unless they're communications to attorneys regarding the subject matter of the case. So if you've got a chat thread, either through your work online database, your management system, your personal cell phones, whatever, be careful about what you're talking about. Be careful about talking about the merits or not of the lawsuit, because those things may ultimately be discovered or partially discovered, such that it could paint you in an unnecessarily negative light. Your attorney is there to protect you. Limit communications. Years ago, I had a client tell me a funny story about somebody that they worked with that was so diligent about not putting things in writing. They were super cautious about it. They used messengers to courier communications back and forth and only communicated on the telephone. So essentially, they would engage somebody whose job it was to remember things and courier information. And no, this was not some illegal thing. This is just the way they conducted business, because they knew that there was an investigation and they didn't want there to be 6,000 text messages, 4,000 VoIP hours of transcribed phone communications, or, thousands and thousands of email chains being produced. One that can drive the cost up, because if it's fair game, it's fair game. You're going to have to produce it. You are going to have to produce it, even though the requesting party asked for it, and you're going to have to bear the cost of giving them what they want. And that's not a cheap thing to do. You usually got to download some software. You got to do a search for that message thread, upload it in that software, and rip it all out on a PDF or a paper production. Can be expensive, especially if the communications go back years. So watch it, especially when you're in the middle of the fight. You have a right to protect yourself. Use it, right? Use the phone. Use the phone. Use your attorney. Stop talking in a way. Don't stop talking in a way that advances your business, but stop talking in a way that may give ammunition to the other side or paint you in a bad light regarding the merits or not of the other side. Even trash talking amongst your business owners against the other business owners can be detrimental, can paint you in a bad light. If you have any questions about this, text Ashmore X2 to 47177. Ashmore X2 47177. Thank you so much. And almost forgot, chat at ashmorelawfirm.com. Hit us up on email, chat at ashmorelawfirm.com.